Welcome in, everybody. Ready to dive deep into American criminal law?
Always ready to explore the legal landscape.
This time, we're tackling a thick textbook you sent over. Criminal law, procedure, and evidence, the whole shebang.
Oh, it's a fascinating journey, that's for sure.
Our mission, to really get a grip on how the U.S. handles criminal cases. And trust me, it's a wild ride.
Buckle up.
All right, let's start with something that seems basic but gets surprisingly complex, the idea of crime. You know, we all kind of have a sense of it, but where did this whole concept come from?
It's a long and winding road, really. Think
Uh-huh.
back to ancient codes, Hammurabi's code, for example. Eye for an eye, pretty straightforward.
Makes sense for the time, I guess.
Then we move on to Roman law, the 12 tables. Things start to get a bit more nuanced proportionality and punishment, the seeds of justice beyond just revenge.
So we're talking about how societal values shape our views on crime.
Exactly.
And how did we go from an eye for an eye to the much more complex systems we have today?
Well, you can't ignore the influence of big thinkers like Plato and Aristotle. Their ideas about justice, morality, the role of law, those had a massive impact on shaping Western legal traditions.
So philosophy meets law, got it. But there's more to it than just the act itself, right?
Right.
The book mentions this idea of mens rea, the guilty mind, and it uses a really interesting example. Let's say someone downloads music illegally, but they genuinely believe the site they're using is legal. They have no intent to break the law. Are they still guilty of copyright infringement?
See, that's where things get tricky. That's where mens rea comes in. Did they intend to commit a crime? If not, it could be a strong defense. It's not just about what they did, but what they intended to do.
It reminds me of that saying, ignorance of the law is no excuse. But is that always true?
You know, it sounds straightforward, but applying it is another story.
Yeah.
It depends, right? The specifics matter, the law in question, the circumstances, but generally you can't just plead ignorance and get off scot-free.
Okay, so intent matters. But then there's the flip side.
The flip side.
Yeah. What about someone intending harm but failing? Like trying to hack a bank but getting caught before stealing anything?
Great example. Even if they don't succeed, they could still face charges. Attempted theft,
Yeah.
cybercrime, things like that. The law sees that intent coupled with actions towards committing a crime that's enough to hold someone accountable.
So intent plus action, key takeaway there. Now, zooming in on the American system, things get even more intricate. We have common law, based on past cases, and statutory law, created by legislatures. How do those two work together?
It's a constant dance. Common law, it's like the foundation, built up over centuries of court decisions. But things change, right? Society evolves. That's where statutory law comes and legislatures making new laws, updating the system.
So it's a conversation between judges and lawmakers.
Exactly. Always shaping and reshaping how we define, how we punish criminal behavior.
And we can't forget the big kahuna in this conversation, the U.S. Constitution.
Oh, absolutely. It's the supreme law, the ultimate rule book.
Right.
And for criminal law, the Bill of Rights is crucial, particularly the 4th, 5th, 6th Amendments. They're like a shield protecting individual rights.
So it's not just about punishing the wrong, but also about protecting the accused.
Absolutely. The Bill of Rights ensures fairness due process throughout the entire system. A great example, the exclusionary rule. Evidence obtained illegally, it can't be used against you in court.
Wait, hold on. Even if the evidence is strong, but the cops messed up, it's tossed out.
It can be. It's definitely controversial. Some say it lets criminals walk on a technicality. But supporters, they argue it's crucial to prevent police overreach. It's like saying, hey, the ends don't justify the means.
I see. Even if the evidence points to guilt, how it was obtained matters. The textbook talks about Weeks v. United States and Mapp v. Ohio, two huge cases that solidified the exclusionary rule in American law.
Exactly. Weeks established at the federal level, Mapp extended it to the states. It's this constant push and pull, individual rights versus effective law enforcement.
It's not just an academic debate, then. It's about real-world consequences.
Real-world consequences, exactly. And that balancing act is at the heart of the 4th Amendment, too. The protection against unreasonable searches and seizures. And of course, that brings us to probable cause.
Okay, probable cause. We hear that phrase a lot. But what does it mean practically? Like, if a cop wants to search me, what do they need? 100% certainty that I'm up to something.
It's not about being absolutely sure. It's about a reasonable belief, a reasonable person looking at the situation and thinking, something's not right here. Based on the facts and circumstances.
So not just a hunch, but a reasoned judgment based on evidence. But how is that applied in different situations, like searching my house versus questioning me on the street?
Good point. The level of probable cause needed, it varies. For a brief street stop, reasonable suspicion is often enough. But to enter your home, they generally need a warrant based on a much stronger level of probable cause.
Okay, that makes sense. Warrants, they add a layer of protection. But what about those scenes we see, cops chasing a suspect, bursting into a building? No time for warrants there.
These are usually what they call exigent circumstances. An immediate threat, or the risk of evidence being destroyed. The need to act fast outweighs the warrant requirement. But the courts, they scrutinize those cases. They want to make sure the police weren't just making up an emergency.
It's like the law tries to account for all the what-ifs and strike that balance, quick action, individual rights.
It does. It really does. And this gets particularly tricky when we talk about searches of, you guessed it, cars.
Ah, cars. Always adding legal wrinkles.
They do. And the book goes into detail here, and for good reason. Cars are mobile, they cross state lines, it's a whole different ballgame.
So let's say I'm driving, get pulled over for speeding. Can the officer just search my car?
No, not automatically. Just because
What?
it's a traffic stop, even for a minor thing like a taillight out that doesn't give them a free pass to search everything,
So what can they search?
they can ask questions, sure, where you're going, what you're doing. And they could look around the interior from where they're standing, a plain view search. But to open compartments, to search the trunk, they usually need probable cause to believe there's evidence of a crime or your consent.
Consent. So if they ask, can I search your car? And I say yes, they're good.
That's right. But that consent has to be genuine, freely given, no coercion. If they threaten you or intimidate you to get that consent, any evidence found, it could be thrown out.
So it's not just about saying yes, it's about knowing my rights, making a choice. What about trickier situations, like where consent isn't so clear?
Passengers in a car. Classic example. Let's say your friend consents to a search, but you object. Can they proceed? The book talks about Georgia v. Randolph. The Supreme Court said if one resident consents, but another resident, present at the time, objects, the search stops. Your right to refuse trumps the other's consent.
So my privacy in the car, even as a passenger, matters.
It absolutely matters. And this generally applies to other places too, like a hotel room. Hotel staff can't consent to a search, only the guest. It all comes back to reasonable expectation of privacy.
Okay, consent searches are fascinating. But let's go back to when police might have probable cause to search a car without a warrant.
Right.
The book talks about the automobile exception, right?
Exactly. It's this exception to the warrant requirement. Because cars are, well, cars. Mobile. Evidence can disappear quickly. The rationale is if the cops had to get a warrant every time they suspected something, criminals could just drive away.
So speed matters when it comes to cars and evidence, but how does it actually work?
Well, there are a lot of nuances, a lot of case law to consider. For instance, in New York v. Belton, the Supreme Court said, the passenger compartment of a car, it's generally fair game if there's a lawful arrest, even if the person's been taken out of the car.
So if I'm arrested after a traffic stop, they can search the area around me, maybe the glove box, under the seats. That sounds pretty broad.
It is, but it's specifically tied to a lawful arrest. The idea being the person might have a weapon or evidence related to the arrest.
But Belton, it's been narrowed over the years. Arizona v. Gant, another key case, it clarified that the search has to happen basically right then and there alongside the arrest, not hours later.
So the immediacy matters.
It does. And there's another limit. The search is limited to the area within the person's reach, or where there's probable cause to think there's evidence related to that specific crime they were arrested for. It can't be a random fishing expedition.
So if I'm arrested for a DUI, they can't be digging through my glove compartment for stolen credit card.
Exactly. It's got to be connected. Now, another scenario. Police have probable cause to think the car itself contains contraband.
Okay, so not an arrest, but suspicion based on something else. What kind of evidence are we talking about?
It could be a tip from a reliable informant, witness statements, suspicious activity, or even something the driver says, something that makes the officer think, hold on, something's not right here. So if I'm acting nervous and there is a slight smell of, say, marijuana, could that be enough?
It's not about individual factors, but the whole picture. If the officer can articulate a reasonable belief that there's something illegal in that car, then they might be able to search without a warrant.
This all seems a bit subjective, though. How do we make sure officers aren't abusing this exception, just searching cars based on gut feeling?
That's where the courts come in. Any evidence found during a warrantless search, it can be challenged. The judge will decide if the officer's actions were reasonable, justified. The Fourth Amendment, it requires more than just hunches.
So even though the automobile exception exists, there are still checks in place.
Absolutely. The courts, they're constantly refining the rules, trying to get that balance right between effective law enforcement and protecting our rights. And, speaking of tricky, we haven't really talked about passengers. What about their rights during a car search?
Right. If the cops are searching a car I'm in and find something, can I object even if it's not my car?
That's where standing comes into play. Just being a passenger doesn't automatically give you the right to challenge the search. You need a reasonable expectation of privacy in that specific area.
So something in the trunk. If I have no reason to think my stuff's in there, I probably can't object.
Exactly. But here's the twist. If the police stop the car illegally, then all passengers, regardless of what was searched, can challenge that stop itself.
Interesting. So even if the evidence isn't mine, if the initial stop was wrong, it could get tossed out.
Potentially. It underscores why lawful stops matter. The Fourth Amendment protects everyone in the vehicle, not just the one behind the wheel.
Makes you think about those pretextual stops you hear about.
Oh, yeah.
Can the police really use a minor traffic thing, like a taillight, as an excuse to stop someone when they're really looking for something else?
That's a big debate. Ethically, legally. The book talks about when in the United States, the Supreme Court said, basically, as long as there's probable cause for that traffic violation, the stop's good, even if the officer had other things in mind.
So a broken taillight becomes a reason to investigate something bigger.
That's the concern, right? Critics say it gives the police too much power, can lead to profiling. But the court focused on the objective reason for the stop, not the officer's, hidden agenda.
Still feels like a slippery slope.
It does. The key is the scope of the stop still has to be reasonable. They can't detain you for hours over a busted taillight.
Right, there have to be limits.
Absolutely. Now, switching gears a bit, the book also talks about stop and frisk.
Oh, this is where they can stop someone and pat them down for weapons. I remember that being a huge issue, especially in cities.
Big issue, for sure. It's that tension between public safety and individual rights. The case Terry v. Ohio is the basis. The Supreme Court said police can briefly detain someone if they have reasonable suspicion of criminal activity.
Reasonable suspicion. That's
Yeah.
less than probable cause, right?
It's a lower standard. Doesn't require that same certainty that a crime's happening. Could be based on the person's behavior, the time, the location, the officer's experience.
But that seems open to a lot of interpretation. What one person thinks is suspicious, another might not.
Exactly. And that's the problem, according to critics. Too much room for abuse, for racial profiling. Florida VJL, that's a key case. An anonymous tip about someone with a gun. The Supreme Court said the tip alone, with nothing else to back it up, isn't enough for a stop and frisk.
So just a random call doesn't give police free rein.
Yup. They need more. Something they can see, something to corroborate that tip.
What about someone running from the police? Isn't that suspicious?
It could be a factor, for sure. Illinois v. Wardlow, the court said, running from the police, especially in a high-crime area, can contribute to reasonable suspicion. But it's not automatic.
So just taking off running doesn't mean they can stop and frisk you.
Not necessarily. You've got to look at the whole picture. What else was going on? The context matters.
So more than just a single action.
Always. And that's why stop and frisk is so controversial. Public safety versus individual rights. Tough balance.
Speaking of rights, let's get back to searches. But this time, consent searches. We touched on cars, but what about, say, my home? Police knock on the door, want to come in.
That's where understanding consent is crucial. It's got to be voluntary. You have the right to say no, and the police can't force you or trick you into agreeing.
So if they say something like, if you don't let us in, we'll just get a warrant, that's a problem.
It could be, especially if they don't have enough for a warrant in the first place. They can't pressure you. Your consent has to be freely given.
What about more subtle pressure, like just asking repeatedly or using intimidating body language?
Those are tricky situations. The courts look closely at those. Even seemingly harmless things like, oh, it'd be easier if you just cooperated, could be seen as coercive. It's about making sure you're not just saying yes because you feel scared or pressured.
So even if I say yes, but it's because I'm intimidated, that's not true consent.
Nope. And this applies to anything, not just homes. Your car, your backpack, even your person.
What if I consent to a search, but they go beyond what I agreed to? Like, I let them search my backpack, but they start going through my pockets.
That's where scope of consent matters. The search can't exceed what you agreed to. There are cases where going beyond that has resulted in evidence being thrown out. It's like a contract both sides have to stick to the terms.
So if I say they can search the living room, They can't use that to go through my bedroom.
Exactly. And if they do, anything they find outside of what you agree to, it could be challenged.
Good reminder to know my rights, to be clear about what I'm allowing if I'm ever in that situation.
Now, speaking of rights, let's talk confessions. We touched on this before, but the book really gets into how they're obtained, when they can be used.
Confessions, they seem so straightforward, but I'm guessing it's not that simple.
It's not. The law knows that confessions can be coerced, forced out of someone. That violates the Fifth Amendment. So there are a lot of safeguards to prevent false confessions, to make sure anything said to law enforcement is truly voluntary.
And Miranda warnings play a big role here, right? The whole "you have the right to remain silent" thing.
Exactly. Miranda v. Arizona, landmark case. Before questioning someone in custody, the police have to inform them of their rights. Right to remain silent, right to a lawyer.
I thought there were exceptions to Miranda, though. Does it always apply?
Not necessarily. The book gets into that. Like, if someone volunteers information without being questioned, or if it's routine booking stuff, not focus on getting them to confess.
So some gray areas, depends on the specifics.
Absolutely. The courts examine the whole situation surrounding a confession. Was it fair? Do they violate the person's rights?
What about the right to have a lawyer during questioning? Is that automatic upon arrest?
Another important one. The Sixth Amendment guarantees a lawyer at all critical stages, and that includes interrogation. Escobedo v. Illinois, that case said once the investigation is focused on a specific suspect, they can have their lawyer there.
So not just being in custody, but when the focus shifts to you specifically?
Exactly. And if you say, I want my lawyer, the questioning stops until your lawyer arrives.
So I say, I want my lawyer, and everything's on hold.
That's how it's supposed to work. And anything said after that, without the lawyer present, it can be thrown out. The book stresses how important it is for people to understand this right and to use it.
Like a shield against unfair questioning.
Exactly. It's a fundamental part of our system, ensuring both sides are represented, keeping things fair.
And that leads us to the rules of evidence. We've talked about how evidence is obtained, but what happens when it's presented in court?
Ah, that's where evidence law comes in. A whole set of rules governing what can be admitted, how it's presented, how much weight the jury can give it, all about fairness and reliability.
So not just a free-for-all.
Nope. Very specific rules. Rules against hearsay, character evidence, prior bad acts, all designed to prevent the jury from being swayed by unreliable or prejudicial information.
I've always wondered about hearsay. Seems like a simple concept. You can't repeat something you heard someone else say. But I know there are exceptions.
Oh yeah, lots of exceptions. Hearsay, basically an out-of-court statement used to prove the truth of what was said. So someone tells you they saw the defendant commit the crime, you repeat that in court. Hearsay.
Because you didn't see it, you're just repeating. But when are the exceptions used?
Each exception has its reasons. Dying declaration. If someone believes they're about to die, their statements can be admitted, even if they can't testify. The idea being they're unlikely to lie when facing death.
Makes sense. What else?
Excited utterances, things said in the heat of the moment during a startling event. They're spontaneous, so less likely to be made out.
So someone sees a hit and run, shouts the license plate, that could be admissible.
Could be. There are also exceptions for statements against interest, business records, public records, even ancient documents. It's a whole balancing act, getting reliable evidence, but recognizing that sometimes the best evidence comes from sources that can't be there in court.
Okay, so hearsay is a complex topic. What about character evidence? Can the prosecution bring up the defendant's past bad behavior to make them look guilty?
That's a tough one. The general rule, no. Character evidence can't be used to prove someone acted in a certain way just because of their past.
So can't say, this person was violent before, so they must have done it this time.
Right. It's about judging them based on this case, not their past.
He's fair.
It is. But there are exceptions. The book mentions a few. If the defendant tries to present themselves as a good person, the prosecution might be able to counter that with evidence of bad character.
So it's strategic.
Very much so. And there are other exceptions. Character evidence to prove motive, opportunity, intent, things like that. It's a balancing act, giving the jury relevant info, but not letting them judge based on prejudice.
Seems tricky. What about past crimes, not just character? Can the prosecution use those?
Another careful area. Generally, no. Can't say they stole before, so they must be stealing now.
Right, that seems unfair.
It is. But again, there are exceptions. Prior crimes to prove motive, opportunity, intent, things like that. Or a common scheme, a pattern.
So, like, If they're accused of robbing a bank with a specific disguise, and they've done that before using the same disguise, it might be relevant.
It might be. But even then, the judge has to decide, does it really help prove something? Or is it just unfairly prejudicial? A tough call sometimes.
Judges have a lot of power when it comes to evidence. How do we make sure they're not biased?
That's the challenge, right?
Yeah.
There are appeals courts that can review decisions, but it comes down to having impartial judges, knowledgeable about evidence, committed to a fair trial.
Makes sense. Now let's talk about something I find really interesting: eyewitness identifications. I've read that they can be surprisingly unreliable.
They can. We think memory is like a video recording, but it's not. The book talks about stress, time, cross-racial identification, even how a lineup is conducted. All these things can affect accuracy.
So even if someone's sure they're right, they could be wrong.
It happens. Memories change. They're influenced by our emotions, what we've seen or heard later.
Scary. What's done to prevent wrongful convictions based on that?
There are safeguards. The Sixth Amendment, the right to counsel, it applies to lineups. So once you're charged, you can have your lawyer there to make sure it's done fairly.
So my lawyer could object if the lineup was biased, like if they made me stand out somehow.
Exactly. And there's a key case, Neal v. Biggers. The Supreme Court had a two-part test. First was the identification procedure itself suggestive, and second, even if it was, is the identification still reliable, considering all the circumstances?
So even a flawed lineup, the ID might be okay if other things point to the witness having a good memory.
That's the idea. How well did they see the suspect? How much time has passed? Things like that.
Complicated stuff.
It is. Eyewitness IDs are powerful, but you got to be careful with them.
Now, something that feels very relevant these days: government surveillance, data breaches, facial recognition, all that.
A hot topic for sure. And the law is scrambling to keep up with technology. The book goes back to the early days, wiretapping. Olmstead v. United States, the court said, wiretapping without a warrant was fine because there was no physical trespass.
Wow, that seems so outdated now.
It is. Katz v. United States, that case changed things. Established reasonable expectation of privacy. So even if there's no physical intrusion, the government can still violate the Fourth Amendment if they're snooping where they shouldn't be.
Makes more sense for today's world. But what is a reasonable expectation of privacy when technology keeps changing things?
The million-dollar question. The courts are wrestling with that constantly. The book talks about how it applies to all kinds of surveillance, wiretapping, emails, GPS tracking.
What about thermal imaging? I remember cases where they use that to, see heat signatures inside homes looking for grow ops.
Another example of technology pushing the boundaries, Kylo v. United States, the Supreme Court said, using thermal imaging on a home without a warrant violated the Fourth Amendment.
So even though they're not physically inside, using technology to get info they wouldn't otherwise have, that's a search.
Exactly. And GPS tracking, too. United States v. Jones, the court said, sticking a tracker on someone's car without a warrant, that's a search. Even though the car's in public, that constant tracking, it went too far.
So the Fourth Amendment protects more than just physical spaces. It's about our privacy in the world.
It is. And the book also touches on drones, for surveillance. Another whole can of worms there.
It's like we're trying to apply old laws to a brand new world.
We are. And nowhere is that more obvious than with national security surveillance.
This is where it gets really tricky. Post 9/11, there were a lot of arguments about how much power the government should have to conduct surveillance for national security reasons.
Big debates. The book talks about the Foreign Intelligence Surveillance Act, FISA, and the Patriot Act. FISA was about regulating surveillance on foreign targets. The Patriot Act expanded those powers after 9/11.
So the government has more leeway when it comes to national security threats.
Generally speaking, yes. But there are still rules. FISA courts are supposed to oversee things, make sure it's justified, legal. But there's a lot of concern about whether that's enough, whether these programs have gone too far in eroding privacy.
Tough situation. We want the government to be able to protect us, but not at the cost of our basic freedoms.
It's a balance. And the book talks about the need for transparency, accountability, making sure these programs are kept in check.
So the Fourth Amendment still matters, even when it's about national security.
It does. And you see that same tension when it comes to border searches.
Border searches. I bet the government has a lot of power there with needing to control who and what comes into the country.
They do. Warrantless searches are allowed at the border, no probable cause needed, so they can search your bags, your car, even you, without any specific reason to think you've done something wrong.
Wow, that's a lot of power. Are there any limits?
There are. The book emphasizes that even though they don't need a warrant, the search still has to be reasonable. They can't just tear everything apart without some justification.
So a basic luggage search might be okay, but a strip search, they'd need more.
Exactly. And then there's the extended border. Warrantless searches are allowed a certain distance from the actual border.
Like a highway checkpoint miles inland.
Right. But there, they need reasonable suspicion that you're involved in some border-related crime smuggling immigration violations.
So not just a free pass to search anyone nearby.
Nope. And the courts have had to figure out what's a reasonable distance? What level of suspicion is enough? It's complicated.
Sounds like it. So border search is another example of balancing the Fourth Amendment with other needs like security and immigration.
Exactly. Now, what about people who are already in the system, like those on probation or parole? Do they have the same Fourth Amendment rights as everyone else?
I'd guess not.
You're right. The book talks about this. Probationers, parolees, they have a lower expectation of privacy. It's part of the deal, basically.
So they've agreed to more intrusion.
In a way, yes. Griffin v. Wisconsin, that case, said a probation officer can search a probationer's home based on reasonable suspicion.
Yeah.
No warrant needed.
So even though they're not in prison, they're still under more scrutiny.
Right. Probation, parole, they're seen as privileges, not rights. The conditions are there to protect the public.
But there have to be limits, right?
Of course. The book makes that clear. Searches still have to be reasonable, connected to the conditions of their release, reasonable suspicion that they're violating those conditions, or that there's evidence of a crime.
So the probation officer can't just barge in whenever they want?
Nope. There has to be a valid reason. And if the probationer or parolee feels their rights were violated, they can challenge it.
So even people who've been convicted, they still have some constitutional protection.
They do. Now, speaking of people operating in a bit of a gray area, let's talk about informants.
Informants, the people who give information to the police, sometimes for a reward or a lighter sentence, always seemed a bit shady to me.
It can be. A lot of ethical and legal concerns. The book talks about the rules around using informants, the challenges of making sure their information is reliable, and making sure they don't cross the line into entrapment.
Entrapment, that's where the government tricks someone into committing a crime, right?
Basically, yeah. And the book goes over the two tests for entrapment. The subjective test, which looks at whether the defendant was already predisposed to commit the crime, and the objective test, which looks at the government's actions, whether they were likely to make even a law-abiding person commit a crime.
So it's not just about the government being involved, it's about whether they push too hard.
Exactly. And those tests, they're not always easy to apply.
Especially with things like drug crimes or organized crime, where informants are already part of that world.
Definitely. The courts have to look closely. What did the informant do? What was their relationship with the defendant? Did they influence the defendant's actions?
Sounds like a minefield.
It can be. Let's circle back to the exclusionary rule. Remember that.
The rule that tosses out illegally obtained evidence.
That's the one. The book goes deep here, back to Weeks v. United States, establishing the rule federally, and then Mapp v. Ohio, extending it to the states.
So a pretty important rule.
It is, but it's always been controversial. The book talks about the pros and cons, the tension between deterring police misconduct and making sure guilty people don't go free just because of a technicality.
Tough balance.
It is. And there are exceptions to the exclusionary rule, reflecting those competing interests.
We talked about a couple like the good faith exception and inevitable discovery.
Right. Good faith if the police thought they were acting legally, even if there was a technical violation, the evidence might still be allowed.
So a warrant that's later found to be faulty, if they were acting in good faith, the evidence might be okay.
Exactly. And inevitable discovery if they would have found the evidence anyway, even if they initially got it illegally, it might be admissible.
So they were doing an illegal search, but they had a valid warrant for the same place. The evidence might still be okay.
That's the idea. These exceptions acknowledge that sometimes the need for justice might outweigh the need to punish police errors.
So the law is always changing, adapting.
It is. Now, let's talk about another fundamental right, the right to counsel.
The Sixth Amendment, everyone has the right to a lawyer in criminal cases, right?
That's right. And the book goes through all the different parts of that right, effective assistance of counsel, right to counsel at different stages, how to waive the right, all
So it's not just having a lawyer there, it's having a good lawyer.
Exactly. Strickland v. Washington, that's a key case. The Supreme Court said there's a two-part test for ineffective assistance of counsel. First, did the lawyer mess up? Did they do something a reasonable lawyer wouldn't do? And second, did that mistake actually harm the defendant's case? Would the outcome have been different with a better lawyer?
So it's not enough to just say, my lawyer made a mistake. You have to show that it really mattered.
Right. And this right to counsel applies to more than just the trial. Pre-trial hearings, plea bargaining, sentencing, appeals.
So even if you plead guilty, you can have a lawyer advise you during plea bargaining and sentencing.
Absolutely. And the book talks about waiving the right to counsel, too. You can do it, but it has to be a clear, informed choice.
So you can't just say, I don't want a lawyer, without understanding what you're giving up.
Exactly. The court wants to make sure you know what you're facing, what the risks are.
The right to counsel, it's a cornerstone of the system. The law wants to make sure everyone has access to legal help when they need it most.
Now, let's look at a specific type of crime that often brings up some tricky legal issues. Conspiracy. Now, let's look at a specific type of crime that often brings up some tricky legal issues. Conspiracy.
Conspiracy. That word always evokes images of shadowy figures plotting in smoke-filled rooms. But legally speaking, what exactly constitutes a conspiracy?
You've got the right idea. It's essentially an agreement between two or more people to commit a crime. The book breaks down the elements of conspiracy, the different types of conspiracies, and the potential defenses to these charges.
So even if the planned crime never actually happens, just agreeing to commit it is enough to be charged with conspiracy.
That's the interesting part. The heart of a conspiracy lies in the agreement itself. And to prove a conspiracy, prosecutors often rely on a key element, the overt act.
Okay, overt act. What does that mean in the context of conspiracy?
It means any action taken in furtherance of the conspiracy. It doesn't have to be the actual crime itself, but it has to be something that demonstrates the conspiracy is moving forward. It could be something as seemingly innocuous as a phone call to discuss plans, a meeting to assign roles, or gathering materials needed for the crime.
So it's about showing that the agreement wasn't just talk, but that the conspirators were taking concrete steps to put their plan into action.
Exactly. And the book dives into different types of conspiracies, each with its own unique structure and challenges for prosecution. For example, there are wheel conspiracies, where a central figure connects to various individuals involved in separate but related criminal activities. Imagine a hub with spokes radiating outward, each spoke representing a different criminal act connected to the central hub.
I can see how that would make it difficult to prove the connections between everyone involved.
It definitely poses challenges. Then there are chain conspiracies, which involve a linear progression of individuals each playing a role in moving the criminal enterprise forward. Think of it like a chain of events where each link represents a different stage of the criminal scheme.
It's fascinating how these different structures reflect the complexity of organized crime or large-scale criminal operations.
Absolutely. And the book also explores potential defenses to conspiracy charges, including withdrawal from the conspiracy and, as we've discussed before, entrapment.
Withdrawal, that means just saying, I'm out. It's not quite that simple. To effectively withdraw from a conspiracy, you have to take affirmative steps to disavow the conspiracy and clearly communicate your withdrawal to the other conspirators. It's not enough to just have a change of heart. You have to take action to distance yourself from the criminal scheme.
So simply ceasing participation isn't enough. You have to make your intentions clear to the others involved.
Exactly. And as with other crimes, entrapment can also be a defense to conspiracy. If the government induced someone to join a conspiracy they wouldn't have otherwise participated in, that could invalidate the entire agreement.
This makes conspiracy seem like a powerful tool for law enforcement, but also one that requires careful and ethical application.
Well said. Now, you mentioned earlier how the criminal justice system can seem like a complex web of laws. This next topic really illustrates that point, the dual sovereignty doctrine.
Dual sovereignty. That sounds intriguing and a bit like a contradiction. How could there be two sovereigns in one legal system? It's a concept that reflects the unique structure of American federalism, where power is divided between the federal government and the states. The dual sovereignty doctrine recognizes that both the federal government and the states have the power to prosecute crimes. This means a person can be prosecuted for the same conduct in both state and federal court without violating the double jeopardy clause of the Fifth Amendment.
Wait a minute. You're saying someone could be tried twice for the same crime. Doesn't that go against the idea of double jeopardy where you can't be tried for the same offense twice?
That's where it gets a bit tricky. It's not about being tried twice for the exact same crime. It's about being tried for violations of different laws. Double jeopardy only prohibits being tried twice for the same offense by the same sovereign.
So if I rob a bank, I could be prosecuted by the state for robbery and by the federal government for bank robbery, even though it's essentially the same act.
That's precisely what the dual sovereignty doctrine allows for. The book highlights a key Supreme Court case on this, Heath v. Alabama. The court reasoned that each sovereign and the federal government and the state has a separate interest in enforcing its laws and protecting its citizens.
So even though it might feel like double punishment legally, it's considered two separate offenses because it violates two different sets of laws.
That's the logic behind the doctrine. Of course, it's a concept that has generated considerable debate and criticism, with some arguing that it allows for overzealous prosecution and potentially unfair consequences for defendants.
It definitely highlights the complexity of our legal system and the sometimes conflicting interests at play. Now let's move on to the final stage of the criminal process, sentencing. It's the moment of truth where the consequences for criminal actions are determined.
Sentencing is a weighty responsibility that rests with the judge. It's about more than just punishment. It's about finding a sentence that balances the needs of society with the circumstances of the individual defendant. The book examines the various factors the judges consider at sentencing, including the severity of the crime, the defendant's criminal history, the impact on the victims, and the need for deterrence, rehabilitation, and incapacitation.
So it's not a one-size-fits-all approach. Each case is unique, and the judge has to weigh a variety of factors to arrive at a just sentence.
That's right. The goal is to find a sentence that fits the crime, that takes into account the defendant's individual circumstances, and that serves the interests of both the defendant and society.
What are some of the different types of sentences judges can impose?
The book outlines a range of options from fines and probation to imprisonment, and in some jurisdictions, even the death penalty. Fines are monetary penalties, probation involves supervision and conditions imposed on the defendant's release, and imprisonment involves incarceration for a specified period of time. The severity of the sentence typically corresponds to the seriousness of the crime and the defendant's criminal history.
Sentencing seems like a particularly challenging aspect of the criminal justice system, as it involves a lot of discretion on the part of the judge and often leads to debate about what constitutes a just and fair punishment.
It certainly is. And the book doesn't shy away from the controversies surrounding sentencing. It explores the ongoing debates about mandatory minimum sentences, which limit judicial discretion by requiring a certain minimum sentence for specific crimes, as well as concerns about racial disparities in sentencing and the overuse of incarceration in the United States.
It's a reminder that the criminal justice system isn't perfect, and there's always room for improvement and reform.
Well said. I think we've explored just about every nook and cranny of this fascinating and at times complex world of American criminal law.
It's been quite a journey. From the ancient roots of law to the modern challenges of technology and surveillance, we've uncovered the intricate workings of the system and how it tries to balance individual rights with the need for order and justice.
One of the key takeaways, I think, is that the law is constantly evolving. It's not a static set of rules, but a dynamic process that's shaped by societal values, technological advancements, and the ongoing dialogue between the courts, lawmakers, and the people.
And I think it's empowering to understand our rights and how the system works. It allows us to participate in that dialogue, to advocate for change, and to hold those in power accountable.
Absolutely. Knowledge is power. And understanding the legal framework that governs criminal law and procedure gives us the tools to navigate this complex landscape and to ensure that justice is served fairly and equitably.
Thank you so much for guiding us through this deep dive. It's been enlightening, and I feel like I have a much better grasp of how this intricate system operates. To our listeners out there, we hope you found this exploration insightful. Stay curious, stay informed, and keep those legal thinking caps on.